Although, is this going to be a split call, or are the Greens going to take their split call? Well, as Honourable David Parker, 5 minutes.
Thank you, Mr. Speaker. I rise to take a call in support of the amending legislation, which is an amendment to the 2016 amendment to the Civil Defence Emergency Management Amendment Act. I agree. In fact, I was somewhat surprised, as I'm sure a lot of members would have been, to learn that there was no power to require the owner of a building that may be in need of repair or assessment as to whether it's safe. There is no regulatory power easily available to the government to require that that building be inspected. So I agree that it's necessary. It's a somewhat small step in that I think we're going to have a serious look in New Zealand as to whether the building code has been up to standard, up to a high enough earthquake prevention standard, given the relatively young age of some of these buildings that are no longer occupied. I think we should also, and this is addressed to the Minister Brownlee, I think we should be looking at whether some of the warnings that were given by occupants of buildings following the 2013 earthquake off Seddon, whether there was damage in 2 buildings or defects shown up in buildings at that time which weren't properly looked into either by landlords or, and I would suspect on other occasions, by government departments. I'm aware of at least one of the buildings that's now unoccupied, Mr. Brownlee. Thank you. Where I am told that in 2013 staff raised concerns as to the integrity of the building and that they were not taken seriously. Now, I don't know whether those accusations are correct. The people who I have that information from are not reckless people. They're people I know quite well and place some trust in their word. And I think we should have a look at whether some of the buildings that are occupied by government departments were showing flaws in 2013 that the management of those organisations didn't respond to adequately. They're actually not buildings that were built during the tenure of the National Government. They were built during the tenure of the prior Labor government. But I have had some suggestion that there were concerns raised in 2013 that weren't looked into properly. Now, we didn't need a new power under the civil defence legislation to require government departments to do what they should have done. We do now sometimes need a power of compulsion in respect of private building owners and private building occupiers, and that's what this bill, this amendment bill does. In respect of the government or the civil defence authorities who are effectively an agent of government in times of emergency, go too far and make an onerous or unreasonable request of a building owner, there is protection set out in Clause 7 of this bill, which inserts the new Clause 26A into the Principal Act, which inserts 26A into the Amendment Act, which changes Section 91 of the underlying Act. It's a bit confusing, but effectively this new power is to be found after this amendment goes through in Section 91 of the underlying Act, and at subsection 6 it says that the owner or the owner's agent may appeal to the District Court on the grounds that the direction is unreasonable. So I presume, and we will ask the Minister this during the committee stage, because whilst I've been racing around trying to follow this through in the underlying amendment, which was just passed in 2016, and in the 2002 Act, I presume that the effect of subsection 7 is to say that they've still got to do the review. They just have to make sure that they just have the ability to get back the cost of that review if the District Court later finds that the request made of them was unreasonable. So, sir, I think that's a fair enough check and balance. I think that the emergency powers of the civil defence people ought to be able to say, you need to get a report now, and if they don't, there needs to be a consequence, and that consequence presumably would enable the recovery manager to direct someone else have access if the owner or the agent has refused to do so. That's another matter we should be checking at the committee stage of this, because if you have got an unreasonable owner, then I think the state should be able to do the report themselves and recover the cost from the building owner.